basically I'll start with the public trust, as the trusts in Maharashtra that are public and religious are generally governed by the act called as Maharashtra Public Trusts Act, and it's 1950 Act, which has been amended from time to time. So first of all, really speaking, the definition of the public trust is important to understand, and thereafter I'll try and give as to what are the necessities of registration as a public trust, and then I will proceed with the functions and powers of the charity commissioner, and also the proceedings that can be instituted before the charity commissioner by the persons who are interested, and also the manner in which the charity commissioner is expected to deal with or adjudicate such applications. So public trust is defined in section 2 subsection 13, and public trust means an express or constructive trust for either public or religious charitable purpose, or both, and include temple, church, synagogue, agyari, or other places of public religious worships, as well as mutt and waqf, or any other religious or charitable endowment and society formed under for the charitable and religious purposes and registered under Societies Registration Act. Now, this is generally speaking the public trust. In Maharashtra, there are many public trusts that are religious, and there are trusts that are only charitable, and they may not be religious. This act, really speaking, applies to almost every trust which is not a private trust. And for private trust, as you must be aware, Indian Trust Act is applicable and not the act which we are currently dealing with. Now, the charity commissioner, who is really speaking is the supervisory body and appointed by the state naturally, has array of functions, including the responsibility and obligation to supervise or rather control the functions of the charity, functions of the public trust. If you understand the sections which I am now going to go through, you will understand that the charity commissioner per se has a very close association, or rather very close control over every trust which is governed by the Maharashtra Public Trust Act. It has, as you will see in the course of my lecture, it has the power to supervise the process, or rather the functions of the trust. It has the power to issue appropriate and necessary directions to have proper administration and management of the trust. It has the power to remove any trustee. It has the power to issue any temporary injunction. It also has the power to suspend a trustee or remove the trustee because of his incapacity or because of his unwillingness to work as a trustee. And quite apart from that, he also has a power to file a suit on behalf of the trust and defend a suit which is also filed against the trust. Now, charity commissioner as an officer of the state is appointed under section 3 of the Maharashtra Public Trust Act. Importantly, it is not only a quasi-judicial authority, it is not only an administrative authority, but it is a judicial as well as a quasi-judicial authority. If you understand the roles and powers given to charity commissioner, you will see such powers are wide enough and also include the administrative powers, inquisitive powers, and really speaking, the charity commissioner has the powers that are delegated by the state to it for ensuring proper functioning and administration of the trusts in the state. Really speaking, it is a wing of the state which has a wide or array of superintendent powers, and it has an obligation to look after the trust funds, trust properties, and look after its management. Now, just to give in information which may not be that important for the present purposes, earlier the age of the charity commissioner for the age of retirement used to be 58, but now it's been made 60. Now, for the functioning of the charity commissioner, there are various officers that are appointed under the section or under the Public Trust Act. Now, these officers include, but not limited to, the appointment of Joint Charity Commissioner and also the Assistant and Deputy Charity Commissioner. Now, Joint Charity Commissioner is naturally, as the name suggests, is the statutory officer appointed by the state to discharge the obligations and functions of the charity commissioner. But naturally, the joint charity commissioner will always be subject to authority and power or supervision of the charity commissioner. Earlier, this provision wasn't there. It was included by invoking the Article 213 Clause 1 of the Constitution. And in year 2000, Joint Charity Commissioner was appointed for the regions of Mumbai and other metro cities of the state of Maharashtra. Now, qualification of the Joint Charity Commissioner I may not go into for the purposes of the present lecture. But just to give you an outline of the qualification, the Joint Charity Commissioner, or rather the Charity Commissioner also, is a judicial officer, which is not lower than the rank of the district court judge and judge of the city civil court or the chief judge of the small causes court. Provided that the judge of the city civil, the appointment can be of some judicial officer not lower in the rank than that of the assistant judge or additional chief judge of the small causes court. There is also the provision under section 4 for direct recruitment of those advocates who have the practice of more than 10 years in the High Court. Now, moving on from this appointment of JCC, that is Joint Charity Commissioner, there are other two sets of the officers that are Assistant Charity Commissioners and Deputy Charity Commissioners. These are also appointed for various regions by the state government, and the powers as well as the functions, as you will understand, are laid down under the various sections of the Act. And the appointment is given under section 5, which I don't want to bore you guys with. But it is very important to see that the Supreme Court, in the judgment of 2003, has said that the office of JCC, that is Joint Charity Commissioner, and as well as the DCC, that is Deputy Charity Commissioner, has to be considered as the court for the purposes of contempt of courts Act. It was 2003 SCC 563 in which this decision was rendered, and this decision was rendered by the Supreme Court keeping in mind the array of functions, the nature of obligations it performs, the offices of JCC and DCC perform, and particularly keeping in mind that the judgments that are passed by JCC and DCC are to an extent final in nature, and they always satisfy or are required to satisfy the test of judicial pronouncement. Now, test of judicial pronouncement is nothing but a detailed reasoning, application of mind, appreciation of facts, as well as whenever necessary, appreciation of evidence led by the parties before it, and giving a reasoned judgment. Now, the sections that I have just touched upon are the sections relating to appointment. Now, the important section, according to me, before moving on to the functions of Charity Commissioner, is necessary to understand what are the charitable purposes. Because religious purposes are quite easy to understand, but sometimes it is difficult to ascertain as to whether a particular or a given purpose is a charitable purpose or not. Whether the trust or the public trust that has taken birth out of the instrument or testamentary instrument or otherwise, and if that trust is to function in accordance with the purposes enlisted in that particular will or a testamentary disposition, then whether such purposes qualify to be called as the charitable purposes or not is something that is laid down in section 9 of the Public Trust Act. Now, please understand that the description given of the charitable purposes in section 9 is not exhaustive. It only lays down a broad or other overview of the purposes that can be termed as charitable purposes. And therefore, it has to be interpreted in the widest possible manner. So, if you see section 9 and if you try and understand what are the charitable purposes, it really speaking lays down that every or other any activity that is towards the relief of poverty or distress in education and medical relief. Also, the facilities that are towards or for recreation and even those facilities that are leisurely activities, but are provided for social welfare and benefits or public benefits, are generally termed as charitable purposes. But at the same time, the Act has carved out an exception to say that religious teaching or propagating a particular religion or imparting a religious education will not be termed as charitable activity. It may be religious activity, it's a different matter altogether, but for the purposes of Section 9, it cannot be a charitable activity. What do you mean by social welfare or public benefit? Because really speaking, any activity which is being done or undertaken by the trust for the social welfare or a public interest or benefit is to be understood to be a charitable activity, and therefore it is necessary to understand what is social welfare and public benefit. Now, in the Act, and also based on certain pronouncements, judicial pronouncements, social activity or a public benefit activity is something or which will include the facilities that uplift the conditions of life of the persons to whom they are intended to be provided. And importantly, such persons should be those who need such facilities on account of their age, infirmities, poverties, disablements, or social and economic circumstances, or at public at large. So, the really speaking, legislative intent is that you can have certain activities that may be termed as social welfare or public benefit if those activities, really speaking, uplift the conditions of life of those persons to whom they are intended to be given. For example, a trust which imparts education or rather provides sports activities for physically disabled or physically challenged students very well can be said to have charitable purposes for a reason that it intends to give benefit of its activities to a particular class of persons who on account of their physical circumstances need such kind of activities or facilities that are being provided by the trust. And therefore, such activities can be said to be charitable purposes and charitable activities. Now, there are various judgments that have been given and pronounced so far, which deal with what are the charitable activities and what are not the charitable activities. So, really speaking, the test for understanding whether a particular charitable activity is indeed a charitable activity or not is dependent or is based on whether by a particular activity or a facility, a public good intended of a particular ascertainable section of the community is being benefited or not, or is being given or not. Now, there are certain questions, or there was a decision of the Bombay High Court wherein the question that was raised was whether a trust having educational institutions and imparting education or providing facilities of education to only those persons or only to those students who have paid fees to have access to such facilities can be said to be a trust having charitable purposes. The Bombay High Court has in its decision said that yes, even if you are though charging fees for imparting education or giving facilities, educational facilities, you are only giving such facilities to those who are paying the fees. That does not mean that you are not providing the charitable activities. Naturally, but the funds that are being accumulated or that are being received towards the fees will have to be expended, will have to be dealt with in accordance with the Act and under the supervision of the Charity Commissioner. But nonetheless, the educational institutions that are giving education at certain fees are still the charitable trusts. Charitable activities are generally defined in the instrument of the trust itself. And the author, at the time of authoring the will generally enlist those activities that the author intends to use the trust funds for. Therefore, sometimes, or rather many a times, it is not that difficult to ascertain what is the purpose, what are the activities for the for the trust, or what are the activities or the purposes for which the trust must come into play. but many a times it is not clear. And in such scenario, the discretion is of the trustees as to which charitable activities, which charitable purpose it wants to utilize its funds, it wants to utilize its property. Now, in recently 2016, even yoga has been considered to be the activity of the welfare, social welfare, and public benefit, and therefore is included as a charitable activity or charitable purpose. But more or less, the charitable activities are such that are used or that are being provided to eradicate the poverty with an object of general public utility. Now, there is one case of the Supreme where the decision was rendered by the Supreme Court, the Trustees of Charity Funds versus Commissioner of Tax, 1959 AR 1959 Supreme Court 1060. The question there was that the trust was giving education, or rather giving facilities primarily to those people who are related or rather the successors of a particular family. And it was intending to eradicate the poverty of those families who are associated with the successors of the trustees or successors of the author of the trust. But nonetheless, it was also giving facilities to other people who intended to be benefited out of that out of such facilities. The Supreme Court has said that even if primary object was to give the education or rather was to give facilities to the people of a particular sect or people of a particular portion, nonetheless, overall or rather general intention of the trust was to give benefit to all the people at large, even if the priority was given or priority was to give facilities to the families of a particular caste or religion. The corollary from this that follows is that the activities or the object which is not for the public good cannot be a charitable. Therefore, if you are going to provide education only to the children of your employees, if you are going to alleviate poverty only of a particular family, if you are going to accord financial help only to a particular family, if you are going to take efforts for advancement of those practicing a particular profession, or if you are going to offer facilities only for the benefit of teachers of particular institute, then such activities cannot be said to be charitable. There is also a question as to whether a trust or whether an activity which involves imparting political knowledge, or rather an activity of the trust which is for the purposes of attaining the political object, whether it is charitable or not. Now, there are various judgments of the Supreme Court as well as the Bombay High Court which says that the political activity or the activity of any particular trust to impart or rather to advance the political thoughts of a particular political party cannot be said to be a charitable activity. But at the same time, any object of promotion of trade, commerce and industry which is going to benefit the public at large is and can be said to be a charitable activity. The political activity cannot be a charitable activity, really speaking, came for the adjudication, judicial adjudication, in the case of Lokmanya Tilak Jubilee National Trust Fund case. It's a case of 1942. And the issue was that the trust, Tilak Trust, was in the process, or the object of the trust was to achieve the political advancement of India, having its goal of acquisitioning complete national autonomy or Swaraj, and naturally of diffusion of political education and propaganda. The court said that such charitable or such activity cannot be said to be a charitable activity because it is not that it is invalid. It is valid. It is a legal objective of any trust, but it is not up to the charity commissioner or for the trust or for the court to ascertain whether a particular object is being satisfied, whether a particular object of the trust is being executed or not. And because of that, the political agenda or the political education or the trust that wants to impart or rather is in the advancement of a particular political thought cannot be said to be a charitable trust. Since 1942 till recent times, the understanding regarding the political views or political propaganda or rather the political education has remained the same. Even today, it is considered to be not charitable, and that is the law of this particular. Now, from this, we move on to the registration of the trust and the authority of the charity commissioner at the time of the registration of the trust. Now, under section 14, 15, 15A, and 16, there are regions and sub-regions and registrations office that are instituted in the state of Maharashtra. Deputy and assistant charity commissioners are always in charge of the public trust registration offices, and therefore an application for registration has to be made to the assistant or deputy charity commissioner. Now, before I move on to the registration, I also want to highlight the register that is maintained in the office of the charity commissioner. Now, this register assumes importance for a particular reason. This register is nothing but a register that will enlist all the particulars of the trust, including its properties and the names of the trustee. This register is maintained under section 17, and any change in this register will have to be brought to the attention of the assistant or deputy charity commissioner, depending on the case, within certain time limit. And this register itself, in the sense that the attempt or rather the need to seek a change in this register has given a wide amount of or rather monumental amount of litigation in the office of the charity commissioner. And I will show you and I'll demonstrate as to how and why. Now, section 18 provides for registration of the trusts. And at the time of registration, now, first of all, it is a duty of every trustee to file an application for registration. Now, sometimes trustees face a very uncertain situation where they themselves aren't aware whether this is a public trust or a private trust. In such situation, the best way ahead or forward is to file an application under protest, application for registration under protest, and leave the matter to the decision of the charity commission. Because the charity when I say charity commissioner in this section, it is joint charity deputy charity commissioner or assistant charity commissioner. These two officers are entrusted with the duty to first find out whether a particular trust falls within the shelter or within the purview or within the ambit of this particular act, whether a particular trust is indeed or rather is a particular is a public trust or public charitable trust or religious trust. Now, therefore, when you file an application under section 18, there are various particulars that you will have to fill, no doubt. But after filing of the application, the job of the assistant charity commissioner or rather the deputy charity commissioner is not a mechanical job. There are various heads or rather there are various aspects that the assistant charity commissioner or deputy charity commissioner must understand, must check or analyze or rather apply his minds before granting registration. And that is in the next section, section 19. But in section 18, the procedure as to how the application for registration is filed is given. Now, when you file an application, naturally you must include what all are the properties of the trust. What all, when I say properties, that includes immovable as well as movables, as well as the liquidity. It also must mention the names of the trustees. It also must mention the mode of succession, in the sense, if a particular trustee or a board of trustees is going to hold the functions or hold the office for a particular period of time, then what is the procedure which is enlisted in the instrument of trust for appointment of the next term or the next trustees once the office is rendered vacant on account of retirement. Therefore, the mode of succession has to be mentioned. When you are ensuring or when you are mentioning the details of the properties, you also have to mention as to how your ownership stands fructified at the time of application of the. So when I say you have to demonstrate your ownership, does not mean that there has to be a proper adjudication on that ownership. But for example, if there is a particular property which stands in the name of the trust, or land that stands in the name of the trust, then naturally there will be a 712 extract. If it's in the vicinity of Mumbai or within the territorial jurisdiction of Mumbai, then there will be a lease deed executed by the collector. If not that, then there will be a property card that will mention the name of the trust as the owner or the lessee, whatever may be the case. So all such documents will have to be submitted for the purposes of registration. Now, what if you don't register the trust? As applicable or rather like section 69 of the Partnership Act, a public trust which is unregistered cannot initiate any legal action or cannot initiate any legal proceedings for the purposes of enforcing its right. Therefore, it is always advisable to have your trust registered, and more importantly, there is a penal provision also. It's a punishable offense in which the trustees will be prosecuted under section 66 of the Public Trust Act. But naturally, such prosecution will not take place unless the Charity Commissioner gives the permission. Now, remember that the registration will always take place or will become effective only upon the date of passing of the order. What I am trying to highlight here is the registration is not retrospective, that is from the date of making an application, but it is always effective from the date of the order. Therefore, whatever are the proceedings that may have been filed between the date of filing the application and the date of the order, according to me, may not stand good or may not be good in law on account of the fact that your public trust was not registered as on the day on which the proceedings were filed. Apart from that, a registration will automatically bring that public trust under the guise or under the auspices or under the purview of the Bombay Public Trust Act or Maharashtra Public Trust Act. So for even making the provisions of the Trust Act applicable to any particular trust, registration is necessary. And it is not that if you don't register, the Charity Commissioner or the Assistant Charity Commissioner or rather the Deputy Charity Commissioner is powerless. As I will explain to you in the forthcoming sections, they can also initiate a suo motu action for the purposes of registration of a public trust, and also punish or rather initiate appropriate action to punish the trustees for not taking action for registration of the trust. Section 19 is basically, as I was telling you earlier, gives the scope of inquiry that Assistant or Deputy Charity Commissioner must undertake before granting the registration, before according the consent for registration or giving the registration certificate to a particular public trust. So what are the parameters or what are the main headings under which he has to inquire? Now, first he has to understand that whether there is a trust, whether the trust exists, and if trust exists, then whether it is a public trust, as in 290, section 2, subsection 90. Whether any property which is enlisted or which is mentioned in the application is of the public trust, and also whether the property mentioned falls within the jurisdiction or a substantial portion of the properties falls within the jurisdiction of that Assistant Charity Commissioner or rather the office of the Charity Commissioner. These are the main aspects, not all, but main aspects on which he is expected to inquire. The ancillary inquiry should be of the names of the trustees, mode of successions, origin, nature and object of such trust, amount of the gross average annual income and expenditure of such trust, and so on and so forth. Importantly, this section, that is section 19, where the Assistant Charity Commissioner and Deputy Charity Commissioner also has the power to decide whether a particular trust is a public trust, whether a particular property is of the public trust, whether the public trust or whether the trust exists or not. These powers, now this is dehouse the connection between section 18 and 19. When I told you section 18 provides an application to be filed, that application has to be decided in accordance with the section 19, which talks about the inquiry to be undertaken by any assistant or deputy charity commissioner before granting registration. But quite apart from that also, if a person having interest, now person having interest is defined in section 2. If person having interest also approaches assistant charity commissioner or deputy charity commissioner saying that you please find out whether this particular trust is a public trust, you also please find out whether this particular property is a public trust property, or you find out whether this particular trust exists or not. And with that application, if he goes to the assistant charity commissioner or deputy charity commissioner, the deputy or assistant charity commissioner is obliged to invoke inquiry, is obliged to invoke section 19, conduct proper inquiry and give its finding.